Good afternoon, everyone. My name is Kristen Solis. I'm one of the mentor attorneys at the Dallas Volunteer Attorney Program, or DVAP as we call it for short. Thank you all for joining us this afternoon for our Consumer Law CLE. For those of you that are not familiar with us, DVAP is a joint program of legal aid and the Dallas Bar, and our primary mission is to match low-income Dallas residents with private pro bono attorneys that will take their case from start to finish. One of the common types of cases that we get in that we are needing volunteers for are consumer law type cases, whether it be a roof repair issue or a car repair issue or some other consumer related case that folks need to get their money back from. So today we are blessed to have two speakers, Michael Hurst and Julie Pettit, to tell us all about consumer law. Michael Hurst is a partner at Lynn Pinker Hurst. He practices complex commercial intellectual property and employment litigation. He is the 2018 past president of the Dallas Bar Association. He's board certified in civil trial law. Among his many accomplishments, he's been named super lawyers, best lawyers in Dallas, best lawyers in Texas, best lawyers in America. He has written on numerous civil trial topics, that sort of thing, and is very passionate about helping people. Among the places he's involved with is the Genesis Women's Shelter, New Friends, New Life, Legal Aid of Northwest Texas, and of course, DVAP. And he has blessed us for several years on mentoring us on these types of cases. Julie Pettit is the founding partner of the Pettit Law Firm, and her focus is on real estate, business, and consumer law cases. She has her bachelor's from Texas A&M and her JD cum laude from SMU. And among her numerous accolades, she's a Rising Star, Texas Monthly, Rising Stars of the Super Lawyers, and one of the best attorneys named by D Magazine. As they present their presentation, if you have questions, feel free to write them in the Q&A. They have got a lot of material to cover, so we may not be able to get to the questions at the end, but you can certainly reach out to them with your questions, and I believe they'll put their contact information at the end. So without further ado, I'll turn it over to Michael.
Hello. It's very good to speak with all of you on something that I think is so incredibly important, and that is taking care of our low-income neighbors. You know, we're very privileged to have our law licenses and be able to practice law and to make a living. But I've always said that in order for our system of justice to work, it has to work for everyone. And DVAP and Legal Aid of Northwest Texas are at the forefront, not just in the city, but really in the state and perhaps beyond, on making sure that happens. I personally, just a little by way of background, began volunteering for pro bono legal services back when I graduated law school. And hold on to your chair, but it was a little bit over 30 years ago. And I did it because I was proud to be a lawyer, and I thought that that was a great way to start giving back early in my career, but also for selfish reasons, because I wanted to get court experience. So I first started volunteering for family law cases and got to court and trial all the time doing pro bono family law cases. And then I found that I was doing so much commercial stuff and even some consumer stuff in my law practice then. That was back when all the giant banks in Dallas and in Texas failed. And there was a whole lot of consumer and debt collection practices going on there. So over the years, I've gone from volunteering to becoming a mentor in the consumer law area so that I can help young lawyers who decide they want to take on cases that way. I'd also like to put in a little bit of a plug for Julie Pettit, my co-counsel, with whom I work quite a bit. She is not only one of the best lawyers that I know, best trial lawyers I know, but she is specifically adept and experienced in handling very complex and very important consumer cases, as well as real estate cases. And so, with that backdrop, I want to just give you a little bit of a signpost about where we're going, and maybe Julie, if we can share screen and go to the outline. Thanks. And I'll go to the next page. But let me tell you kind of where, and Julie and I huddled on this a couple of weeks ago to decide how we were going to address this and what is most important. And the cases that we have handled over the years have generally fallen into three big categories. Those categories are the basic consumer protection, in which I'll talk to you in a minute about the DTPA, the Texas Deceptive Trade Practices Act, which is probably the greatest weapon consumers have in the state of Texas. That also kind of dovetails into breach of warranty law. Julie's going to talk about the Texas Lemon Law. These are all questions that I got not only from pro bono legal services out of law school, but from every family member or friend imaginable wants to know about the Texas Lemon Law and how they get to return their car. Second big category is the Fair Debt Collection Practices Act, the debt collection practices and what's acceptable and what's not, what's actionable. And those are very important and things that you would end up helping consumers or pro bono legal services clients handle. And the final thing, and again, I'm going to defer almost exclusively to Julie on this because she's a master, but the Residential Construction Liability Act, when your client buys a house or a piece of property, they construct some kind of construction, residential house, and there's defects associated with that. Texas has laws to protect that too. And so we're going to talk about all three of those. Without further ado, let's go ahead and get into the consumer protection stuff. And I want to talk to you at first about the DTPA. The DTPA, again, I mentioned a second ago, I think it is one of the greatest weapons that a consumer has in the state of Texas. And it's been taken more than just somebody that gets sold a small item in a store. The DTPA has actually been used in very large and complex cases too, depending upon and also in a lot of class actions, depending upon the size of the transaction and what will and to help you there. But the DTPA in general sense is set forth in 17.45. It's to protect consumers against false, misleading, or deceptive trade practices act. Deceptive trade practices. And it protects consumers from unconscionable actions, breach of warranties, and what have you. So I divide DTPA claims into three different categories because really that's what 17.50 does. And 17.50 says that you have three ways to bring a claim under the DTPA, and they're not mutually exclusive. You can bring a claim under any of the three. The first one is, sorry, I'm skipping around. The first category is a laundry list, which we'll get to here in a second. The laundry list is specifically enumerated in 17.46B. The second is breaches of warranty, both express and implied. And the third is unconscionable course of conduct. So before I get to what constitutes those three buckets, and I want to talk about what the DTPA, who it protects and who it doesn't protect. If you are a business consumer, that could be an individual or a company, and you have net assets of greater than $25 million, you can't bring a claim under the DTPA. Now, for most of us in this world, that really doesn't rule us out, right? and so the DTPA can be brought by very wealthy individuals or companies as long as their net assets are not in excess of $25 million or more. So it's done to protect consumers, but consumers can be corporations or partnerships. I'll go to the next slide. Okay, so the DTPA, and let me remind you, because I don't remember if we put this in our PowerPoint presentation or not, but the way to initially diagnose and determine whether you have a DTPA claim, you want to do that first and foremost. The second thing that you need to do, though, as a precursor to filing a claim under the Deceptive Trade Practices Act is you have to have to send a demand letter. And that's the one thing that the Act provides. And the Act is, it's not a short demand, a short fuse demand letter. You've got to give the prospective defendant 60 days in which to respond to the demand letter. And you've got to provide in very detailed manner the reasons why you are trying to go after them under the DTPA. And they have 60 days to try to fix whatever that is. And you also have a right to demand in that demand letter that the attorney's fees associated with your investigation and preparation of the demand letter get reimbursed. So, elements of a DTPA claim. A consumer may maintain a suit when any of the following is a producing cause of economic damages or even mental anguish damages. This is why the DTPA is so powerful, at least one of the reasons, and that is you don't even have to show economic damages. You can recover mental anguish damages under the DTPA. Producing cause is specifically defined in the statute, but the threshold to get into a DTPA claim is false, misleading, or deceptive practices, breach of a warranty, or unconscionable course of conduct, and we're not going to talk as much about that, a violation of the insurance code. So if you have a bad faith claim, if you're representing a corporation or an individual that has a bad faith claim against an insurance company, the DTPA can apply to the bad faith claim too, and allow for the damages, including the treble damages that are potentially available under the DTPA.
One thing I'll add on that just briefly is I know I've gotten in situations in the past where we have a lawsuit on file and then I realize, wow, I think maybe there's a DTPA claim here that I didn't think about prior to the time we filed the case. That's okay. It's not too late. You haven't ruined anything. So what you need to do is you can add the claim. The other side has the right to abate the case for 60 days, that 60-day period that Michael was just talking about. But don't think that if you didn't bring the claim in the beginning that you're ruined. So go ahead and still add it and just realize that the case might get abated for 60 days. And
I'm so glad you brought that up because I did forget to mention that. And the truth of the matter is that applies to the beginning of the case too. You can file. You're not going to get in trouble for filing a DTPA case without sending the demand letter. But like Julie said, the case can be abated at the request of the defendant automatically if the DTPA demand letter has not been provided, and that's okay. All right, let's talk about damages and what kind of remedies the DTPA provides. We already talked about mental anguish. It can be the economic damages, so it could be the value of what was you were supposed to receive in the transaction, like for buying a piano or some piece of furniture or some household appliance to compared to what was represented to you. If it was a defective product, if it was misleading, if it was not sold as advertised, those are different ways that the DTPA could apply, and economic damages can be proved up and submitted to the trier of fact, which is the judge or the jury, of course. If the fact finder, that is the judge or the jury, finds that the conduct was committed knowingly or intentionally, the consumer may recover damages not only from mental anguish, but treble damages, 3 times the amount of the economic damages. Another reason why the DTPA is so powerful is this treble damages provision. It makes it powerful and it makes it scary. And then you can also, in addition to all of those things, including the punitive or treble damages, you can recover attorney's fees. So that's it. Some of the examples of a DTPA and when the DTPA is used, Julie, if we go to the next slide, please, is that somebody is charged improperly for a car repair. They were not charged as they were represented to be charged, or the work wasn't done as represented. It can be a homeowner buying a home. It could be businesses purchasing materials, individuals, or any individual or business buying, any type of consumer type item that you would think of that you would go to the store and buy. And also it applies in franchises, subject to the $400,000 limitation. So let me talk to you about the categories and kind of what they go under. And I will tell you, my DTPA demand letters are always very extensive. And if possible, I want to allege all three categories if I can. I want to allege the laundry list, the warranty, and the unconscionable conduct. Let's go ahead and talk about the laundry list first. If you have a business and commerce code, which is what we're talking about here, and you have you have it open it to 17.46B, because 17.46B lists 27 discrete items of which constitute a laundry list violation under the Deceptive Trade Practices Act. That and Julie was kind enough to, I wanted her to put all of them on there, and she told me I was crazy, and she's usually right. But I said, well, let's at least put some of them on there to give a flavor, and then maybe I'll sneak behind her back and read them off of the statute itself. But let me just give you an example, because if you can't find a consumer transaction that falls under the laundry list, you're probably not looking hard enough. It encompasses so much. So passing off goods and services as those of another, causing confusion or misunderstanding as to the source, sponsorship, approval, or certification of goods or services, causing confusion or misunderstanding as to the affiliation, connection, certification, using deceptive representations of geographic origin in the goods or services. You represent this as these pistachios are from Iran, and in reality they're from West Texas somewhere. I mean, those are scratching the surface, representing that they have sponsorship, approval, characteristics, ingredients, benefits. I mean, any kind of misrepresentation, and I could go on and on. I told Julia, so let's at least go 10. So I'll at least maybe tell you the next 6 through 10, which is representing the goods are original or new when they're not. Representing the goods are of a particular standard, quality, or grade when they are not. Advertising goods and services with the intent not to sell them as advertised, or disparaging the goods or services of a business by another false or misleading representation of facts. So many potential areas under the laundry list violations that, like I said, if there is a claim somewhere, you should be able to find one or more of the categories that applies. Usually in my DTPA demand letters, I list multiple categories. Okay, second, and that is after you go look at the laundry list violations, you go into a warranty. So any breach of warranty, ordinary breach of warranty, can also fall under the DTPA if you qualify as a consumer. So breaches of warranty would include an express warranty. For instance, you buy a product and it's warranted to last for 1 year or 2 years or whatever it is, and it doesn't last them, and they don't honor the warranty. You buy a new recreational vehicle, you buy a four-wheeler or something like that, and you got a 1 year or 2 year warranty. After 6 months, it's not starting, it's not working, and the salesperson or the manufacturer is not doing anything about it. And so that would be an express breach of warranty. The implied warranties, which are on the next page, and there are so many different types of common law implied warranties. I think the one that I use the most, let me get to the express warranties elements before I get to the implied warranties. The express warranties, the elements are listed on the screen right there. And essentially you're just making a representation regarding the warranty. It turns out to be false. And the plaintiff, the consumer, has to notify of the breach, and you have to suffer injury because of it. Not too hard to figure out on the express breach of warranty. Let's talk about the implied warranties. The first one's implied warranties for service. That's a newer implied warranty that you see come up a little bit more. Most of the DTPA cases I handled or filed, way back when I started practicing law, they were not implied warranties for service. They were something that came about from again, I think more recent case law, but that's one implied warranty. The ones that we mostly see in DTPA cases are the top two on this next slide, which is merchantability and fitness for a particular purpose. Those are ones where if somebody sells you a refrigerator, well, a refrigerator is, the particular purpose that it was designed for is to keep whatever's inside that ice box at X degrees, and it doesn't keep it at X degrees, then you have breached the implied warranty for fitness for a particular purpose, and possibly the implied warranty for merchantability, in that it is not doing what it said it was supposed to do, and why you bought it in the first place. And so those are pretty easy implied warranties to show in the event that the consumer has been harmed or breached. Again, much crossover with the laundry list of items that would be in 17.46B. Also notice the other implied warranties, they all apply. Implied warranty of title, meaning that you actually own what you sold or didn't own what you sold. Implied warranty against infringement. There's a course of dealing and a usage and trade, which are companion items. Let me tell you about the third item under the DTPA, and that is unconscionable conduct. And this applies very often as well. The unconscionable conduct is essentially taking advantage of a consumer. A lot of times it's unequal bargaining power. The cases really define unconscionability more than the statute does, but the cases specifically say that unconscionability is an objective standard for which scienter is irrelevant. That to prove an unconscionable action or course of action, a plaintiff must show that the defendant's act took advantage of their lack of knowledge and that the resulting unfairness was glaringly noticeable, flagrant, complete, and unmitigated. And probably one of the most cited DTPA cases is the Texas Supreme Court case from 1995, Parkway versus Woodruff. You'll see that a lot if you start handling these types of cases. And unconscionability is defined there as the seller takes advantage of the special skills and training or time of the sale. I can go on and on about what the cases hold on unconscionability, but those are the three categories under the DTPA. Again, usually my DTPA demand letters address all two, saying, laundry list items 1, 4, 6, and 27 have been violated. In addition, they violated the implied warranty of merchantability. In addition, you've committed unconscionable conduct by taking unfair advantage of my client in various ways, shape, or forms. With that, let me go ahead and transition and let Julie talk about what my family's favorite thing to talk about after I was out of law school, and that's the lemon law.
Okay, so lemon law, of course, is when you have a vehicle that's under warranty and which you're having incredibly difficult times getting repaired if it's something that is covered under the warranty. So that's something that you want to keep in mind when you're starting out looking at one of these is there a warranty, and is this something that is covered by the warranty? So you're going to want to make sure you're familiar with that. It applies to new vehicles that are covered, or used vehicles if they're still under warranty. So the question is how to determine if your car is a lemon. It must meet all of these requirements that we have here on the screen. It's got a substantial manufacturing defect. It's something that's covered. The owner has reported it within the warranty term, and the owner gives the dealer a reasonable number of attempts to repair it, which I'll talk about here in a second. The owner gives the manufacturer written notice of the defect and at least one opportunity to cure, and the defect persists and of course impairs the vehicle's use or market value. So the question then is, has the dealer had a reasonable number of repairs? There's 3 different tests that we'll go through. The first is the 4 times test. The second is a serious safety hazard test, and the third is a 30-day test. And here's how each of those work. The 4 times test is, did the consumer passes this test if you've taken the car in 4 times with the same defect within the first 24 months or 24,000 miles, whichever is first, and the defect is still not repaired. personal story, not one from Michael's family, but I had purchased a car and the radio just wouldn't work. After I took it in for the third time for the same defect, and they knew they weren't making any progress, they, in my opinion, went above and beyond and put some special notation in their system. So now, even years later, when I go in, I get very special treatment, I think, from being a problem customer with the non-working radio. So make sure you go in 4 times, and maybe around the 3rd time they start to address you a little bit different. So the second one is the serious safety hazard test. That is if you've taken it, you pass this test if you've taken the vehicle in for repairs for a serious safety hazard twice during the first 24 months or 24,000 miles, whichever is first, and it's still not repaired. So you'll want to determine if that, whatever the issue is something that's a safety hazard. And then the last is a 30-day test, which the consumer passes if the vehicle has been out of service for repair for a covered defect, and it's been out essentially 30 days or more during the first, again, 24 months or 24,000 miles. So if you have this potential issue come up, go through those tests and hopefully see if one of them is met. Then you go through the process of how you actually address it if you think that you have a limit. So you have to file a complaint within 6 months of the earlier of a expiration of the express warranty, 24 months after purchase, and again, 24,000 miles. So you see those 24 months and 24,000 miles keep coming up. So you want to pay attention to those items. You file your complaint actually with the DMV, and then there's a procedure by which they hear from you, they hear from the other side, they make a decision, and then if you're not happy with the decision, it can be appealed in Travis County and District Court. So if you've got one of these issues, make sure that you follow that exact procedure to have your hearing in front of the examiner at the DMV. And then what are the remedies? The remedies are either a refund or a placement or repair of the car, because the DMV will essentially instruct them that they've got to do one of the following. Now we are on debt collection issues, and we'll start with the Texas Debt Collection Act.
Yeah, so there are two, there is a federal Fair Debt Collections Practices Act, and then in 1977, the Texas developed its own Texas Fair Debt Collections Practices Act, as Julie put on there in the Texas Finance Code. It is a statute that was put into place to protect consumers against debt collectors from abusive, fraudulent, or misleading tactics. And it's been amended multiple times. I think this is another situation where I was, when I was out of law school, and again, I mentioned all the bank failures, and it was amazing how many debt collectors were out there, people working on behalf of banks, failed banks, the RTC, which many of you probably don't remember then, the Resolution Trust Corporation, the FDIC, and then FSLIC, and they were all employing people to try to collect debts, and it was very heavy-handed. The Fair Debt Collection Practices Act applies to things like credit cards and mortgages. It does not apply to income tax or parking tickets. It doesn't apply to child support. It doesn't apply to alimony and what have you. And the things that are really most notable, and I'll let Julie kind of go through this if you want, but if a debt collector makes continued attempts to collect a debt that wasn't owed, if they use illegal or unethical communication tactics like threatening violence or criminal acts, cussing somebody out, using bad language, they won't disclose or verify the debt. They threaten to, they make false statements or false representations about who they are or what they're doing, or they take information and they improperly share it, or they improperly contact you. And then there's the repeated phone calls. I don't know if y'all ever saw that movie Swingers in the 90s, where John Favreau kept calling his the girlfriend that broke up with him over and over and over again. that would probably have been a violation of the Fair Debt Collection Practices Act had she had he been trying to collect on the debt. You just can't use the telephone and such for that type of behavior. Sorry, Julie.
Yeah, I had a case that went to trial a couple of years ago in federal court against a mortgage lender where we had evidence that our client was current and not delinquent at all in the mortgage. The mortgage company had an internal error where they had miscalculated the client's escrow account. So we knew we were going to be able to prove up the client was current. In the meantime, this lender, like a lot of lenders, has robocalls that go out. And so this lender multiple times, like, I don't know, sometimes a dozen times a day, would be placing these phone calls to our client who legitimately was current on the loan. So during the litigation, we did request, because they kept copies internally of the robocalls that went out to my client. And it was so much fun in front of the jury to be able to go through all of these calls and just show how harassing it really was for this family who wasn't behind on their mortgage. So it can be pretty powerful stuff if you can end up being able to prove how many calls these robocalls are sending out to your clients every day.
Or your family members. And that's another thing that I always got called about, was family members. And what Julie just put on the screen there, the fraudulent tactics, that's on the Attorney General, the Texas Attorney General's website. These are examples of, as Julie was just going through, specific illegal tactics that are being used, false name, misrepresenting the amount of the debt, trying to pretend like you're sending official court documents when they're really just coming from the debt collector. Debt collector, by the way, has a specific definition in there, and it really applies to if I owe Julie some money, allegedly, and Julie contracts that to Kristen to come collect that, and Kristen is the one that's acting as a debt collector, then both Kristen and Julie could be liable for these violations. Misrepresenting the nature of the services rendered by the collection agency, and falsely representing that the collector has information like, you're not going to believe what I've got right here and how I'm going to use it against you. Well, I'm not going to tell you, but just wait and see. Those are potential violations, or a lot of times it's excessive, usurious, or otherwise improper penalties that are being threatened. Julie, you want to address the remedies? You want me to?
Sure. There are criminal and civil remedies for any sort of violations. As the plaintiff, you can recover damages, injunctive relief, and attorney's fees. So that's the great part about this particular statute, as well as the recoverability of attorney's fees. And then the state can criminally prosecute the offender. I don't know how often that actually happens, but it is at least out there. Disputing the debt is another part of it. So if your client is disputing the legitimacy of something in the debt, you have to give them written notice. So a lot of people will say, well, I told them that I paid that medical bill or whatever. That's not enough. You're going to have to send it in writing, and then the debt collector has 30 days to determine whether or not the item is correct. And a lot of times, if you put that in writing, you send it to the debt collector disputing the debt. There's a lot of debt collectors that, for whatever reason, aren't set up to properly respond to these timely. I guess they're just have a volume practice or whatnot. So a lot of times you can actually get rid of a debt if you properly send that notice and they don't respond. So it's a pretty powerful tool that we have.
Yes.
Okay. Oh, sorry, go ahead.
No, absolutely. And that's what you need to do. There are powerful words, and I think we're on that right now. But if the debt collector, if you dispute that debt, and disputing that debt will, in fact, and you need to do it in writing, but that needs to deter the debt collector. If it does not deter the debt collector, then they can be in serious hot water and subject to liability.
And this last bullet point we have, if they decide that the debt is not accurate, then they have to make the change, and that includes on your credit report. And then they're supposed to notify anyone that has received a report with that incorrect item. So it kind of gives them a lot of homework that they have to do as well. So again, it's a pretty powerful tool that we have here in Texas.
Agreed. I very much agree. And then there's a statute of limitations, and it's a 4-year statute of limitations on debt. That's just like ordinary breach of contract law. If the debt collector is trying to pursue an action that is barred by the statute of limitations, that in and of itself can be a violation of the Texas Fair Debt Collections Practices Acts. Like Julie says, very, very strong and powerful statute, and one that probably more lawyers than not do not know how to use, do not use. And so if you familiarize yourself with that act, you are going to get a leg up on many of your competitors.
Okay, the next part we want to talk about is defective workmanship, and specifically the RCLA, or the Residential Construction Liability Act, which I think is also something that a lot of people aren't aware of. So what the act covers is essentially when you have a contractor that comes out to your house, your client's house, and they've done work that you believe is defective or constitutes some sort of construction defect. This particular section of the property code is extremely specific and has a lot of really important timing issues, both for you and for the contractor. So if you think you've got an issue here, be sure to pull out your property code and go through it literally line by line, because the timing of it is so important, and it is extremely powerful. Like I said, a lot of contractors are familiar with it, probably just from prior issues or whatnot. So if you send a letter pursuant to the RCLA, you'd be surprised at how quickly you may get their attention, because they know that they can be in serious trouble if they don't take it seriously if you're making an RCLA demand. So the steps to follow, we've put them up here on the screen. I won't spend too much time on them, but basically you've got to give them written notice. Once you do that, they then have the chance to come back out to your house and look at it. Sometimes we've got homeowners that are like, well, I don't want them out at my house to look at it. I don't trust them, whatever. Too bad. They have a chance to inspect it. So they're going to get to come take a look at it. And the important part about this is you want to make sure that your homeowner doesn't go, destroy the work or have someone else redo it before you go through this. So for example, if you have someone that says their tile contractor messed everything up, and when they contact you, they've already destroyed, the tile that was put down, and had someone else come in and redo it, well, you're not going to be able to use this particular provision because the prior contractor doesn't have a chance to inspect it. So try to stop your client from going in and making the repairs correct if you're wanting to take advantage of the statute. So you allow the contractor to come in and inspect, and then they have to make a written settlement offer to the claimant. Your client can then, of course, accept the offer, in which there's a 45-day period that they have to make the repairs. And again, some clients say, well, at this point, I've lost all faith in this contractor. I don't want them to come in and make repairs. That's understandable, but this is just how our statute works. Or if they don't think that's reasonable, then they can state in writing why you don't think this offer is unreasonable, or excuse me, why the offer is unreasonable. And then the contractor can make another supplemental offer if they want. And all of those are very specific time periods here to make sure to pay attention to that. So then what are the remedies? If your client rejects what is later determined to be a reasonable offer and doesn't allow the contractor to come in and inspect, then they're limited on the number of damages that they can recover. They can't recover in excess of either the fair market value of the contractor's last offer, the amount of reasonable monetary settlement or purchase offer, and reasonable and necessary attorney's fees incurred before the offer was rejected. So you're basically capped if you don't follow this specifically. Now, there's another weird part of the RCLA. I don't have it here in the slide, but there's a section under 24.002, which is this buyback provision, which is causing a lot of problems these days. And here's why. So there is a provision in the RCLA that if you contact your contractor and say, hey, there's a construction defect, and the contractor decides that making the repairs would be more costly than the fair market value of the property, then the contractor can say, look, we're just going to buy the property back. And that's a risk of using the RCLA because technically the contractor or builder can come back in and say, fine, we'll take your house back. With the way that the obviously housing market has gone recently, the amount of the buyback is what the homeowner originally paid plus some other ancillary issues. So you can imagine a lot of homeowners really don't want the builder to come back in and buy back the house because their home has gone up so much in value. But again, read that portion of it if you think that's a potential situation that you might get into with the builder. All right, the remedies. We've gone through. We have one more slide on them. Let's see. Yeah. Now, if the contract, so the prior slide, these are remedies for your client, the claimant. This is if the contractor doesn't make a reasonable offer, which in my experience seems to be the more likely scenario. But so that's going to limit them. So if the contractor doesn't make a reasonable offer, the limitation of damages does not apply. And then at this point, you can recover, your client can recover the cost to repair, the cost to repair the damaged goods, if there are any, reasonable necessary engineering and consulting fees, which is a huge one because a lot of times, even in litigation, you may not get expert fees, but that's not the case here. You can get engineering and consulting fees. The unreasonable expenses of the reasonable expenses of temporary housing, the reduction in the market value of your house if it's some sort of structural failure, and then your attorney's fees. So all of those are things that you can recover. So you can see how strong this particular provision is if you know how to use it and follow the timelines that are in that section of the property code. That's it.
Those are the main categories that we deal with in consumer law and consumer litigation. There are others, for instance, fair credit reporting and what have you, but those, both from the standpoint of somebody who does a little bit of or uses consumer law litigation or litigation statutes in his practice, as well as somebody who has volunteered and now mentors for pro bono legal work. Those are the main categories. I noticed there was a question or two in the Q&A. I answered one of them regarding the failure to send a DTPA demand letter. I believe the next one may have been targeted at Julie about whether a tractor implicates the lemon law, and I have my thought on that. But let's
I do not. I think we'd have to go to the definition section unless Michael has it committed to memory. I do not know. I've never looked into whether a tractor applies.
I'm just going to say it does, and if it doesn't, the DTPA will apply. If it's as a consumer transaction, so it's either one or both. But is a tractor a vehicle? I don't know if it has to be street legal or not, but there is consumer protection, and again, certainly under the DTPA and possibly under the lemon law. What else? Other questions or thoughts? Anybody listening on here that thinks we got it wrong? We can look in the Q&A, and we see that there are no open questions right now. Well, I want to at least make sure that you have our contact information. As Kristen mentioned, I'm Michael Hurst. I'm a partner with Lynn Pinker-Hurst and Schwegman. And my telephone number is 214-981-3800.
And my name is Julie Pettit again. And I'm not sure if our contact information is on the PowerPoint. If not, we can put that on. We can put it on there when it gets mailed out. But my number is 214-329-1846. And it looks like they have posted the CLE code in the chat box. So be sure you mark that down if you're needing CLE credit for this.
Absolutely. Well, it's a pleasure speaking with you. We wish we could see you and interact directly with you, but I guess it's the next best thing. And at least I got to see the faces of my good friends at Legal Aid. So
Thank you, Michael and Julie, for that great presentation.